Assalamu alaikum warahmatullah.
वालेकुम अस्सलाम वरहमतुल्लाहि
वालेकुम
वबरकातुहू।
सलाम।
Can we start the session?
Yes, please.
Okay. Today we have three most important topics. One is the share of the child to be born. Second topic is the leaving inheritance shares. There are some condition if somebody wants to leave the his or her inheritance share. And third topic is the inheritance rights and shares of Islamic Muslim women. First, we will discuss the share of the child to be born. And share of the child to be born, I have explained in this book in depth, but I will take only one example in this session. And that is the little bit introduction of the share of the child to be born. The better way is that after the birth of the child, we have to distribute the shares, but sometimes lot of issues are there. If the properties belongs to the crore, then the people's doesn't wait. They want immediately in the distribution of the inheritance among the heirs. So scholars provide us two options what we can do because we doesn't know the newborn baby will be the child, will be the son or the daughter, or the girl or the boy. So we will take the two assumption. In the first calculation, we will take the son, or in the second calculation, we will take the daughter. We will calculate the columns in two ways. And as we know that, because we have already discussed in two or three lecture, the share and the daughter and the share of the son, if the separate daughter and single daughter or two daughters, or if there is no daughter, only son is there, number of shares are different. So what will be the procedure to resolve this issue? For example, we are taking one example. Let's say if in the one calculation, if we are getting the total number of share is 32, and in the second calculation, if we are getting the total number of share is 24, so we will find out the ratio of the both the share, and after getting the ratio, we will cross multiply so that we can get the common denominator. So the common denominator after simplifying this equation, that is the common denominator 96 in both the cases. So scholar says in both the situation find out the minimum share of the heirs, and minimum share can be paid before the birth of the child, and rest of the share we can save for the newborn baby. The saved share have the share of the both present heirs and the child to be born. It can be the daughter or son or real brother or real sister, or can be the grandson or granddaughter. Do not draw the line on the screen. This is the first question. In that question, the deceased person is the Nasir, and he left behind his wife, mother, father, and a daughter. Four heirs of the deceased person was there, but his wife was pregnant. So, at the time of the death of the Nasir, the wife was pregnant. So, the newborn child can be the son or can be the daughter. The question says distribute the inheritance among the present inheritors and how much share will be saved for each inheritors. So, to solve this question, we will consider the two options. In case one, we are considering newborn child or newborn baby is son. But why people are drawing the lines? If they are not interested, they can exit from the class. Or I will remove the person who will draw the line on my screen. If anybody is not interested in for this class, he or she can exit from the class, no problem. So we are discussing the newborn child in case one is son. So the present heirs, according to the question, is the wife, mother, father, and one daughter. And son under bracket CBB means child to be born, that is in the pregnancy. So the share of the wife will be 1 by 8 due to the presence of the kids, and the share of the mother will be 1 by 6, share of the father will be 1 by 6 due to the son. If only daughter was there, then the share of the father will be 1 by 6 and R. So these are the primary heirs, only three, and son and daughter belongs to the residuary heirs. Daughter belongs to the residuary by another due to son, and son category belongs to residuary by himself. So according to the Sahih al-Bukhari 6732, first share will be distributed among the primary heirs, that is the ZF or the primary heirs. So how many primary heirs we have? Wife, mother, and the father. The share of the wife is 1 by 8, mother is 1 by 6, and the father is 1 by 6. So the LCM will be the 24. And if you will simplify this, you will find out after the simplification, the resultant will be the 11 oblique 24. That will go to the wife, mother, and the father. Now, the share of the, you can say residuary, and son and daughter both belongs to the residuary. Share of the son and the daughter, that is R, equal to whole estate of the deceased person minus total share of the ZF, that is the 11 oblique 24. So when you will simplify it, you will find out the remaining share or estate that will be distributed between the son and daughter is, that is 13 oblique 24. So according to the Surah An-Nisa, Yusikumullahu fi awladikum lidzakari mislu hazzul unsayayn. The share of son is 2 and the share of daughter is 1. So addition of their ratio is 2 plus 1 equal to 3. So if we will calculate the share of the son, the remaining share is 13 by 24 in step 3, part A. And the ratio of the son is 2 and the addition of ratio is 3. So when you will cut the 24, that is 12, and 12 multiplied by 13, that is 36, and that is 13. Share of the daughter will be calculated with the help of the same formula, remaining share, and the ratio of the daughter and addition of ratio, that is the 13 oblique 72. So the total shares in first case, if we are considering the newborn baby age or newborn child is son, in that case, total property of the deceased person will be divided into the 72 parts, and from the 72 parts, 9 parts will go to the wife and 12 part go to the mother and father each, and 26 part will go to the child to be born, and 13 parts will go to the daughter. That is the case 1 summary. If we are considering the case 2, that is the case second or 2, the daughter, in that case, present heirs are the wife, mother, father, and the first daughter and the second daughter, that is in the pregnancy, child to be born. So in that case, there are 2 daughter. So due to the daughter, the father becomes the primary heirs as well as the residuary by himself. So the father will get the 2 share. 1 by 6 is the reserved. And if something is left, then the value of the R will also go to the father. So in that case, the total share of the primary heirs, wife 1 by 8, mother 1 by 6, father 1 by 6, and the each daughter have the 1 by 3 and 1 by 3. So when you will simplify it, you will find out the value is coming 27 oblique 24, and 27 oblique 24 is greater than 1. It's a case of all, AWL, all. How to execute this one? According to the Hazrat Umar radiallahu ta'ala anhu, we will replace this one, and this 27 numerator will place in case of the LCM. So the share of the wife will be 3 by 27, mother and father will be 4 by 27, and each daughter will be 8 by 27. So in that case, total property will be divided into the 27 parts. 3 parts will go to the wife, 4 parts each will go to the mother and father, and 8 parts will go to the both the daughter. So in both the cases, we can see that in the first case, the total share in case of the son, if we are considering the property was distributing, dividing into the 72 parts, while in case of the daughter, the property is dividing into the 27 parts. Now, the problem is that how we can give the share to the present inheritors, how to calculate, how to find out the minimum share. So 72 and the 27, both the numbers can be divided with the common number, that is 9. If we divide by 72 by 9 and 23 by 9, the ratio will be, that is on the next page, 72 and 27 if we are dividing by 9. So that will be the 8 oblique 3, and we will cross multiply this one to get the common denominator, or you can say common total number of shares. So in that case, we will multiply each year's shares via 3, and in that case, we will multiply by 8. That is illustrated in table number 1. We know that in case of the case 1, that is the case of the son, Share of the wife was the 9, and the mother and the father was the 12, and the CBB was the 26, and the daughter was the 13. That was the 27 shares, total share before the multiplication. If we multiply via 3, so after the multiplication, wife share becomes the 27, mother share becomes the 36, and father is also 36, and CBB share, that becomes the 78, and the daughter share becomes the 39. So it becomes the 216. And in second case, if we are considering the newborn child is the daughter, so in case of the daughter, share of the wife was the 3, mother and father was the 4, and the CBB daughter or the daughter 1 share was the 8. But when we will case 2, multiply case 2 via 8, after the multiplication, the share of the wife is 24, share of the mother and father is 24, and the daughter is 64 and 64. In both the condition, we can find out the total share is the 216. Now, scholar says in both the tables, find out in which table share of wife is minimum. So in that case, 24, share of mother is 32 minimum, share of father is 32 minimum here in case second, or you can say table number 1, part 2 or case 2. While in case of the son and daughter, because present in the present here, there is no share, there is no son. In present here, only daughter is there, only wife is present, mother is present, father is present, and daughter 1 is present. So daughter 1 minimum share in the case 1 is 39. So we will pay to the present years 24 share, 32 share, 32 share, and the 39 share. And the rest of the share will be saved till the time of the birth of the baby. So this is the table number 2 in which we have explained these are the present inheritors. We can give the share to the present inheritors, minimum share 24, 32, 32, and 39. So 127 share will paid before the birth of the child. And total share was the 216. And when you will minus the 127, so 89 share will be saved for the present heirs and the child to be born. So let's suppose if after the birth we see that newborn child is son, then according to the table 1 and case 1, the share of the son will be 78. Go to the table 1 and case 1, table 1 and case 1. If the newborn baby is son, so the share of the son will be 78 from the 89. From the 89. According to the table 2, the total saved share for the present inheritors and the child to be born is 89. And from the 89, we will pay to the son. And rest of the share, according to the table 1 and case 1, will go to the wife, mother, and father, because we have already paid to wife 24 share, and mother and father we have paid the 32 share. But in case of the son, the share of the wife is 27 and we have paid only 24. So we will pay 3 more share. Similarly, we have paid the 32 share. So we'll pay here how many share? 4 share to the mother and 4 share to the father. That is 36 and 36. That is explained here so that we can distribute the 89 share if the newborn child is son. But if the newborn child is not the son, newborn child is daughter. So again, the same table number 1 and case number 2. Newborn child share is 64 and how many share we have saved? 89. Then 64 share will go to the newborn daughter. So it will be the 5 and 25. 25 share will go to the daughter 1. That is daughter 1, that is the newborn daughter is the daughter 2 because daughter 1 already received the 39 share before the birth of the child. So the summary of this solution is that total inheritance will be divided into 2/1/6 part, and before the birth of the child, wife will get the 24 share and father and the mother will get the 32 share and 39 share will go to the daughter 1 or elder daughter, and 89 share will remain the for the new baby or the present inheritors. So after the birth of the child, if the child is son, then from the 89 share, that is the 89 share, 78 will go to the son, 3 will go to the wife, and 4 will go to the father and mother. But if the newborn baby is daughter, then the 89 share will be distributed like this one. 64 share will go to the new daughter and 25 share will go to the elder daughter. That is the daughter number 1 and daughter number 2. So that is the solution if we want to distribute the inheritance before the birth of the child. But the better way is that we have to wait because we don't know, maybe possible to daughters or to son, or maybe the child born dead. Multiple condition can be exist. I have take out only 2 condition. From the one pregnancy, only one kids, I am taking the son and the daughter, but that is the method we can resolve the issues with the help of this method. Now we are going to discuss the another chapter of the today's session, leaving inheritance share. Leaving inheritance shares means takharuj in terms of the madaris terminology. If somebody wants to leave his or her share, what will be the procedure? Today, I think if somebody wants to leave his or her share, that must be documented because may be possible after some time he or she can claim I didn't say anything. The better way is that if somebody wants to leave his or her inheritance, a paperwork must be carried out among the inheritors. Now, what is the procedure of the leaving the inheritance shares? That is known as the takharuj. If you'll go to the multiple books of the Islamic law of succession or Islamic Qanun-e-Warasat, you will find out only 2 option is there. This one and this one. In the takharuj, lots of the book says there is the condition someone can surrender his or her inheritance share on his or her own with demand and other inheritors must agree to that demand. Let's say after the death of the someone, heirs can say, I want the garden, car, flat or a shop or etc. And the rest of the property you can distribute But in that case, the law is that if this is the deceased person and 1, 2, 3, 4, 5, these are the 5 heirs, and this heir says, I want the car of the father. And if 2, 3, 4, and 5, all heirs are agree, then this can be executed. And this is another special case. Someone can surrender his or her inheritance on his or her own because she or he has the debt cause or of the deceits. And in the debt, we have the two components, money or the meher, dowry. If someone not paid the dowry or the meher of the wife, then at the time of the distribution of the inheritance, first this will be take out from his inheritance and it will give to the wife, and then again the distribution will take place. So we have the two options here, but one I have also written one option is there. If somebody wants to surrender his or her estate without any demand, it is also the applicable case. But what is the procedure? We have two methods. If somebody wants to leave his or her inheritance share, we have to include in the calculation. If we are ignoring the person who wants to leave or surrender his share, then the rest of the inheritor share will be disturbed. That we will see in the calculation. So we have mentioned here two methods. And from the both method, we will resolve this case. Let's say on the death of the Jamila, her total estate cost was 6 lakh and had following inheritors: husband, mother, and real uncle. Real uncle means father, real brother. Okay. Her husband did not pay her door amount, yani meher. That's why her husband doesn't want to take his inheritance share and want to distribute among the rest of the inheritors. जमीला की डेथ हो चुकी है और उसने 6 लाख रुपए छोड़े हैं एंड बिहाइंड डेट अपने शौहर, माँ और रियल अंकल को छोड़ा है। शौहर ने मेहर की रकम अदा नहीं की थी अपनी बीवी की, और उसको अपनी बीवी से शेयर भी मिल रहा है। तो शायद शर्म की वजह से या किसी और वजूहात की वजह से वो अब अपना हिस्सा जो बनता है वो भी छोड़ना चाहता है। तो क्या हम शौहर को आइसोलेट कर दें फ्रॉम द बिगनिंग, और वी हैव टू इंक्लूड द हस्बैंड इन द कैलकुलेशन? So we have the two method here. The first method is that we are considering the husband of the deceased and there is no kids, then the share of the husband will be 1 by 2 due to no kids, and the share of the mother will be 1 by 3, and both are the primary heirs. Both are the primary heirs. And real uncle, asbabi nafsi, or you can say residuary by himself, he will get the residue after giving the share to the husband and the mother. So in the step number 2, we are calculating the total share of the primary heirs, that is the 5/6. It means the share left for the uncle or father real brother, that is 1/6. It means in step number 4, if we put the value of all the heirs, we can see that the whole property will be divided into 6 parts, and from the 6 part, 3 part will go to the husband, and 2 part will go to the mother, and 1 part will go to the real uncle. If you want to calculate the shares in amount, so the formula will be one share amount or amount of 1 part will be the inheritance amount, that is the 6 lakh, and the total number of division, that is the 6, because the whole estate is dividing into the 6 part. So that this is the value of the one amount or one share amount. So the share of the husband, because the husband is getting the 3 share, mother is getting the 2 share, and the real uncle is getting the 1 share, and the 1 share amount is 1 lakh rupees. That's why husband will get the 3 lakh, mother will get the 2 lakh, and the real uncle will get the 1 lakh from the share estate of the Jamila. But here the question is that husband of the Jamila does want to take his share, means 3 lakh rupees he want to distribute among the rest of the inheritors, means mother and the real uncle. So how to distribute the 3 lakh of the husband between the mother and the real uncle? We have to calculate the ratio first. So the ratio of the mother and the real uncle is 2:1, and the addition of their ratio is 3. So to calculate the share of the mother and the share of the real uncle, that is the amount of the share belongs to the husband. Husband want to leave this share and wants this share 3 lakh will be distributed among the mother and the real uncle. So the ratio of the mother is 2 and the addition of ratio is 3. When you will simplify it, you will see that from the 3 lakh rupees of the husband, 2 lakh will go to the mother, and how much real uncle will get the share? So the real uncle will get the share, that is the leaving amount or inheritance share of the husband, and a real uncle will get only 1 share, and total division is 3, or you can say total ratio is 3. So from the 3 lakh, 2 lakh will go to the mother, and 1 lakh will go to the real uncle. So if we add both the share of the mother from the 6 lakh, mother is getting the 4 lakh, because receiving directly from the Jamila and receiving the husband of the Jamila, that is 2 lakh. So the 4 lakh is going to the mother. And similarly, how much share uncle is receiving? Uncle is also receiving the 1 lakh directly from the deceits, and 1 lakh from the husband of the Jamila. So real uncle is getting the 2 lakh rupees. That is the method first we are calculating. But this is the method number 2. Method 1 and method 2 results are the same. So when you will follow the method 2, you will find out it's the easiest method with respect to the method 1, because in the method 1 we are calculating 2 times. Residue amount we are again distributing between the mother and the uncle. But in method number 2, what we are doing, that is the husband, mother, and the real uncle. Step 1 is the exactly the same that was in the method number 1. Step number 2 is also the same, and step number 3 is the same. But in step number 4, we are keeping the heirs all the heirs, husband, mother, and real uncle, and we are canceling or dropping the share of the person who does not want to take his or her share. So here husband doesn't want to take his share, but we are keeping in the calculation so that we can go to the other year's fractional share. So we are removing this one from the here. So the remaining heirs are the mother and the real uncle. And we can see here mother share is 2 and the real uncle share is 1. It means the total estate of the deceased will be divided into 3 parts. It means we divide the 6 lakh rupees via 3. So the one share will be the 2 lakh rupees. And how much share mother is getting 2 shares. So multiply the 2 share with the 2 lakh, you will get the 4 lakh rupees. Directly we are getting the answer here. We are not distributing 2 times. In a single instant, we are getting the result. And uncle will get the 2 lakh rupees. So we can see that in the both the method, the final answer is the same. So the better way is that we have to proceed such type of question with the help of the method number 2. But most of the book that is we learn in the Madaris, they distribute the solution, they provide the solution for the Takharuj in this manner. They are first distributing the amount and again they won't they distribute the amount if somebody wants to leave the share in this manner. So it's a lengthy procedure. The better way is that we can resolve the issues in this method. That is the method number 2 is the better solution. There is one more issue is there. If someone wants to leave his or her inheritance and we isolate that person from the beginning, then what will happen? Let's say if we are isolating the Jamila's husband from the beginning and we are thinking if he doesn't want to take the share, so we will not include in the calculation, then see what will be the result. So if we are taking the mother and the real uncle only, and we are isolating the Jamila's husband, then what will happen? Of the 6 lakh rupees, the share of the mother will be 1 by 3, and the rest of the share will go to the uncle. It means that 2 by 3 share will go to the uncle, and 1 by 3 will go to the mother. It means 6 lakh divided by 1 by 3, that is the 2 lakh is going to the mother, and 2 by 3 of this one, that is the 2 lakh, and multiplied by 2, here 4 lakh is going to the real uncle. So whatever the amount of the husband, that is the 3 lakh, mother is getting nothing, because I have put a note here. It's very clear that the isolation of the husband right from the beginning affect the mother share. She is getting nothing from the left out share of Jamila's husband, because she is getting her predefined share, that is the 2 lakh rupees. Leaving out share of the Jamila's husband is only going to the real uncle and not to the mother. So if we are isolating someone from the calculation who doesn't want to take his or her hair, then such type of issues can occur. So take care of the person who wants to leave his or her share, keep it in the calculation till we will not find out the fractional shares. So that was the second discussion of today's session. And the third is the most important part, that is the share of the women's. I have written the separate book on this topic and define the four chapters. And I will take the example from each chapter, only single example, so that I can prove mathematically when a woman share is greater than a man, when a woman share is equal to man, when women inherit but not men, and when a woman share is lesser than men. We will take out all these examples. Generally, we know that women always get less share with respect to the man. That is totally wrong. So this is the first discussion when a woman share is greater than a man. So we can take one example here. In that case, we can see that the deceased left behind husband, father, mother, and two daughters. In this case, husband is a primary heirs, father is primary heirs, ZF, Zabil Fruz or primary heirs, and as well as the father is the residuary by himself. So the father will get the share twice, 1/6 and plus R if any residue is left. Share of the mother is 1/6 due to the presence of the daughter, and the share of two daughter is 2/3. So when you will simplify it, the total share of the inheritors, and you put all these shares, husband, father, mother, and two daughters, you can see that that is coming greater than 1. There is no remaining share for the father, but it's a case of all, A and Waulam all or AWL all. And the share of two daughters, you can see here how many shares of the two daughters is there. You will replace this one and the 15 will place in place of the 12. So the share of the two daughters will be how much? 8/15. So when you will simplify it, 8/15, 8/15, that is 53.33. That is 53.33%. Two daughters in case number one is taking the share 53.33%. But let's assume in place of the two daughters, if we are taking the two sons, if we are taking the two sons in place of the two daughters, husband, mother, husband, father, mother is the same. Husband, father, mother. Instead of the two daughters, if we are taking the two sons, then how much share two sons will get? Husband 1/4 due to the presence of the kid, father 1/6, mother 1/6, and the two sons will get the residue. So when you will simplify this one, husband, father, and the mother, that is the 1/4 and the 1/6 and 1/6. The LCM will be the how much? That is the 12. 4 threes are, 6 twos are, and 6 twos are. That is 4 and 3, that is 7/12, means this R will be 1 minus 7/12. So this is 12. 12 minus 7, that is 5/12. So if two son is there, they will get the 5/12. Now 5/12 you can see that multiply by 100, how much it's coming? 41.67. That is 41.67%. So you can see that clearly if two daughter is there, so the share of the two daughter is 8 by 15, that is the 8 oblique 15, that is the 53%. If two daughters, in any case, that is the 53.33% share is there. If in place of the two daughters, if we are considering the two sons, the share of the two sons is less than the share of the two daughters. So I have explained here and written here, that is the share of the woman is greater than with respect to the, that is the two daughters and that is the two sons. So we can conclude from the case 1 and case 2, woman is getting the more share with respect to the men. Now from the second chapter, we are taking the example, man and woman get the equal share. So in that case, the seats left behind, husband and the daughter. Husband is primary heirs and daughter is also the primary heirs. The share of the husband is 1 by 4 due to the presence of the daughter, and the share of the daughter is 1 by 2. So in step 2, when you will calculate the total share of the ZF, you will find out that is the 3 by 4 less than 1. It's a case of Rad. We have discussed 2 days back. And when the husband or the wife is present in case of the Rad, so the residue will not return back to the husband. So according to the Umar radiallahu ta'ala anhu, the predefined share will go to the husband first, that is 1 by 4, and the rest of the share will go to the daughter. It means that is 3 by 4. The daughter is getting the 75% of the state. In the same case, in place of the daughter, if we are taking the son here, then you will see that husband is primary heirs, will take the 1 by 4 share, and the son is the residuary by himself. So according to the 6732 Sahih al-Bukhari, the fixed share will go to the primary heirs and the residue will go to the closest male relative, and that is the closest male relative son in that case. So 1 by 4 will go to this husband, and the rest of the shares 3 by 4 will go to the son. So son is also getting the 75%, and the daughter is also getting the 75%. So in that case, we have proved that man and woman both are getting the equal share. Now take the another example here. Let's say wife along with the daughter. The share of the wife is 1 by 8 in the presence of the daughter. Share of one daughter is 1 by 2. If we simplify this one, the final answer will be the 5 oblique 8. That is the case of the rag. If the wife is present, so the share, predefined share will go to the wife and the rest of the amount will go to the daughter. So 7 by 8, that is the 87.5% share will go to the daughter. If we are taking the son in place of the daughter, so the son will be the residuary and the wife is the primary heirs. So the share of the wife is 1 by 8 and the residue will go to the son 7 by 8. So in that case, we can see that with the help of the two case studies, the share of the woman and the man is equal. And the first case, we have take out the share, woman is getting the more share with respect to the men, because two women was getting the share 53.33 and two son was getting the share 41.67%. But in that case, when the woman share and the men share is equal, we can see that with the help of the two examples, case 1, case 2 and case 3, case 4, both are getting the equal share. Now we are going to the next chapter of this book. When women get the share when woman share is equal to man, that we have already discussed. And that is the third chapter, when women inherit but not men. And in some cases, not all the cases, in some cases, woman is getting the share and man is not. Let's consider one example here. And in this example, we can see that lot of heirs are there. Husband always primary heirs getting 1 by 4 because due to the presence of the daughter or the granddaughter. Father is primary heirs as well as the residuary due to the presence of the daughter or granddaughter. And mother is always primary heirs and get the 1 by 6 due to the presence of the kids. Daughter will get the 1 by 2. And if the daughter and the granddaughter coexist, then the share of the granddaughter will be the 1 by 6 that we have already discussed. And that is also mentioned in one hadith of the Sahih al-Bukhari. We can go to the website, that is iirc.org.in. We can read in the English language, let's say hadith, English. And that is the hadith. We can take this one. If the deceased person left behind daughter, then the share of the daughter is half. And son's daughter is 1/6. And the rest of the amount, if left, that will go to the real sister. So here, the share of the daughter is 1 by 2 and the share of the granddaughter is 1 by 6. So we are taking this rule from this hadith, that is the hadith number 6736. So share of the granddaughter is 1 by 6 due to presence of the daughter. If the daughter is not there, then the share of the granddaughter will be the 1 by 2. So if we are adding the all the primary share, husband 1 by 4, father, mother is 1 by 6, daughter 1 by 2, and granddaughter 1 by 6, you will see that that is the case of the all greater than 1. So we'll replace the LCM with the numerator, and the new share for the granddaughter will be how much? That is the 15. So this becomes the 2 by 15. We are focusing on the share of the granddaughter. 2 by 15. When 2 by 15, let's say this is the 2 by 15. 2 by 15. 2 by 15 multiplied by 100, you can see that 2 by 15. Oh, sorry. 2 by 15 multiplied by 100. That is 13.33%. So in that case, the granddaughter is getting the 13.33%. But in the same question, in place of the granddaughter, if we want to take the grandson, let's say we are taking the grandson, so the share of the husband is 1 by 4, share of father is 1 by 6, mother is 1 by 6, daughter is 1 by 2, all are the primary heirs. And according to the 6732, Sahih al-Bukhari give the share, fixed share to the primary heirs, and the residue will go to the closest residuary. The closest residuary in that case is the grandson, and that is belongs to residuary by himself. So if you will simplify the total share of the heirs in case of the primary heirs, you can see that the share of the husband is 1 by 4, and the father is 1 by 6, mother is 1 by 6, and the daughter is 1 by 6. And you can see yourself, that is 13/12 greater than 1. So there is no share, there is no residue for the grandson. So we can see that, we can say that sometimes in some cases, woman is getting the share, but not the man, because granddaughter is getting the 33.33 while the grandson is not getting any share. And the last discussion of today's session is when woman's share is lesser than amen. That we knows every time. Huh? Let's say we have the son and daughter, then the total estate of the deceased person will be divided because that is the ABG asbabi ghairihi, or you can say daughter is residuary by another, and the son is always residuary by himself. So the son will get the two share and the daughter will get the one share. So in that case, the share of the son will be the 66.67%, but the share of the daughter is that is 33%. So we can see that the share of the woman is less than share of the man, but it's not the case of the son and daughter. We can take the another example. In that case, there is no son and no daughter. Okay. But we always talking about the son and daughter. But in that case, too, there is no son and no daughter, father and the mother. So if there is no kid, then the share of the mother is 1 by 3. And in that case, the father becomes the residuary asaba binafsihi or residuary by himself. So the residue will go to the father. It means the share of the father is 2 by 3. So when you will take out the percentage, you can see that 2 by 3 means 66.67% and 1 by 3 means 33.33%. So share of the woman is less than man. But it's not always son and daughter. Can be the other person also. Let's say real brother, real sister, paternal brother, paternal sister, father and mother. Lot of condition can be exist. I have completed all these topic of the today's session. If you have any query, you can discuss your personal scenarios with me. Or if anybody wants to leave the session, he or she can leave the session. If somebody wants to stay with me, he or she can ask the question. I have the time, 1 hour time with you.
Sir, I have a question.
Okay.
Uh, the example which you have shown, I mean, in one of the example, the
Your,
remaining amount for distribution is 89 share, which you can distribute post. We know that
your,
post.
your, your voice is not clear. Please clear it, please. Okay.
Is it clear now?
Now it's clear now.
Okay, sir.
Tell me
In the one of
point to
in
point.
the one of the example you have mentioned that the child to be born case, wherein the
Okay. Okay.
89 was a remaining share which
Oh,
can be distributed post the child is born.
okay.
Sir, but for calculation purpose,
Hmm.
it looks like justified because we have calculated as per the method. But
Okay.
if we go to the real fact, suppose the person, diseased person has left a building,
Hmm.
a property,
Hmm.
and father, mother, whatever the case may be, the total share. Now, how it will be distributed and how the 89 remaining will be kept, and we have to wait for the newborn, then the 89 share to be distributed. I mean, practically, how it is possible?
See, in the previous lecture, somebody discussed with me, and I have told him today's scholar says whatever the estate or whatever the land, whatever the share, bitcoins, you will calculate each and everything in terms of the amount till the property is not distributing. For that time, we can make the documentation or paper, the name of person, date of death, leaving behind the following years. We can make the everything is documented, how much share in the amount, how much share in the percentage. If you are not feasible for the 89 share, you can take out the percentage from there. How much percentage we can save for the child to be born and how much percentage of share we can give to the present heirs. There is no issue.
No, sir, that I understood.
Hmm.
I just wanted to know practically, suppose as I mentioned, it's a building, and how to allocate the property so that only 89 share or whatever the percentage will be kept without distributing, so that it will be distributed upon happening of the case whether the child is born or not born. So how to allocate before that? If there is only one building wherein father stays, mother stays, son stays, so how to allocate, or will not allocate, will calculate only and wait till the things happen, then only will allocate the property. How it will be done? Allocation part, how to be done?
See, that's depend upon the mutual understanding of the person of that family.
Hmm.
Court can't do anything, any mufti can't do anything. There was the one question raised from the New Delhi 25, Abul Fazal Enclave,
Hmm.
part 1. I am living in the same area.
Hmm.
In that area, there was the one flat is there,
Hmm.
and the son was deceased. After
Hmm.
the death of the son, he left behind the father and his wife and
Hmm.
one small son and daughter, 4 years and the 2 years.
Hmm.
And after the death of this son, this flat belongs to
Hmm.
this son.
Hmm.
After the death of this son, this father, or you can say that is the grandfather of the son and daughter, or you can say father of this son,
Hmm.
demanding, I want my share in the property of my son. So, according to the Islamic Sharia, the
Hmm.
share of this father is 1 by 6, that is 16.67%, whatever is the cost of the flat. Okay.
Hmm.
If
Hmm.
we are considering the cost of the flat is, let's say, 1 lakh rupees, it
Hmm.
means the share of this father is how much? 16 lakh. That not 16 lakh. How much it will be? 16,667.67, 1 by 6
Hmm.
of the
Right.
Malik, right? So, what is the solution is that Islam doesn't want we sell out this building immediately after the death of this person and all comes on the road. That Islam doesn't want.
Hmm.
Islam wants everybody wants to survive, and we can resolve this issue. This 16.67 amount, we have the two options. We can make one paper and we can write a document that was my son, or this wife can write that person was my husband. After the death of this one, this property now belongs to the one, two, three, four, five members. The share of this father, mother, this wife, and son and daughter is such and such and such. Whenever the property will sell out, this person will get this share. If this father is not agree, then what a wife can do? He can take the help with the brother and sister. He can sold his jewelry and give this amount to this susar or the father of this son, and make the signature ki I have given your amount, that is 667 to you. Now the property belongs to me only and my son and daughter only. These are the mutual understanding solution.
Okay.
Okay, got it?
Okay. Fine.
Any other question?
No, sir. I have got question.
Anyone have any question? And if anybody is interested, he and she can join my class. You can send the request to me, 9871481152, because only 5, 6, or 10 hours is not enough to understand the Muslim law of succession. I am running the 3-month batches. Every Friday, I am taking the classes 9 to 10 p.m. in the evening, and I am giving the homework for the whole week. I am taking the 8 and 9 question in the session and also giving the 8 and 9 questions to you. And approximately you will do the 200 plus questions in the 3 months. And inshallah, you will learn each and everything because 10 hours will not give is sufficient for this course. That is only the just trial awareness of the Muslim law of succession. If anybody is interested, he can send the message to me. My name is Anwar. I will join in the batch number 22 is running currently and 5 lecture already completed. On coming Saturday, 6 lecture will go on. And we have not discussed in that class doctrine of all, we have not discussed doctrine of Rad, we have not discussed whatever today we have learned, we have not discussed in this class, in that class. So if you will join that class, definitely you will get the good knowledge. Any question, please, or we can leave? Yeah.
I cannot see the number fully. 987148.
1152.
Okay, fine.
Okay, you can write your name and the position and the state and what your profile. I will add into the group. Anybody else want to ask the question?
Assalamu alaikum, sir.
Walaikum
I have a
salam.
question. I thought it is said that father, mother, they are primary hairs. I'm just wondering, I want to know why
Just,
in
just,
some.
just wait. See, you are, if you are asking the question, please go slowly and slowly, point wise, one to one.
Okay. My question, my doubt is
Okay.
why son or daughter is not primary hairs in some cases?
Why son and
Son or daughter, why the child is not a primary hair. In some cases, I. Uh,
why son and daughter is not, son is always residuary, not the primary is always residuary.
all okay. Oh, never.
Daughter is, if the daughter is alone, only one daughter, she will get 1/2 primary years. If two or more daughter, they will get the 2/3 primary years. When the daughter with the son, then daughter becomes the residuary due to this son. If the daughter doesn't go to the residuary, then son sometimes son will not get anything. So that is the sacrifice. I will say that is the sacrifice of the daughter. Due to the daughter, the son is getting. Because according to the 6732, all the residuary candidates will get the share when the primary share heirs will get the share. So there is no any list of the son and the grandson or the real brother or the paternal brother. They are always residuary. Because before the Islamic era, if you will find out the inheritance distribution, mother, father, wife, and kids, no share in the inheritance before the Islamic era. But when the Surah An-Nisa 4:11 and 4:12, at the time of the battle of the Jang-e-Ahad, there is one companion of the Prophet Muhammad Sallallahu peace be upon him, Saad bin Rabi radiallahu ta'ala anhu, get the shahadat in the battle of the Ahad. His wife came with the two daughters and said to the Prophet Muhammad Sallallahu the whatever the money belongs to the Saad bin Rabi radiallahu anhu is taken by the brother or the uncle of the two daughters, how the marriage will take place of the daughters and the other thing. Then this ayah 4:11 and the 4:12 yusikumullahu fi awladikum lidzakari mislu hazzil unsayayn and walakum nisfu ma taraka. Then the Prophet ﷺ sent the message to the brother of the Saad and convey the message, the share of the wife is 1/8 and the share of the daughter is 2/3, and whatever is remaining, that is yours. So Allah subhanahu wa ta'ala reversed the procedure of the distribution. Before the Islamic era, there was the no share of the person who was the weekend, mother, father, wife, and the kids. The person who was the strong, he was the eligible according to the traditional concept of the Arab country. He take out the all the property, but Islam says the share of the woman and the man and the kids, mother, father, wife, and all types of the woman. You can see that I have discussed in the first lecture. There are list of the 9 women is there and 4 men is there. 4 men are the husband and father and grandfather and maternal brother, and there is no son in that list. Why there is no son? That you can ask to the Allah subhanahu wa ta'ala after the death, huh? Because we can follow the order, whatever is written in the Holy Quran. We are not following the rule given by the Supreme Court or given by the High Court. Huh? Our High Court and the Supreme Court is the Holy Quran. Understood?
Yes, Jazakallah khair, sir.
Any other question? Laws of inheritance is very simple law, but the problem is that we are not learning. And you can see yourself, more than 42% was there in the class in the first session. How many is there today? 23, only half is there. Any other question? Can we close the session right now? If nobody have the question. Tomorrow we have the last session of this certification course. And the topic of the last session is rules given by the Hazrat Umar radiallahu ta'ala anhu, and we will find out the shortcut method to calculate the inheritance share, and we will take some kind of test. We will send the test paper in the group, and Advocate Falai will send you the test paper, and you will submit the test paper during the class time, and that based on the objective question and answer, you will tick on that answer only. And I think approximately 20 or 25 question will be there. All will be the objective type, or I will keep 1 or 2 mathematical calculation, but not lengthy calculation like this one we have discussed, share of the child to be born or share of the inheritance, Islamic inheritance share of Muslim woman and share of the grandson and granddaughter. We will take the simple calculation, 2 or 3 questions. Inshallah, I will drop the paper to the Advocate Fly, and he will forward in your group. And we will take your test after we will start the class 3 p.m. and at 4 p.m. we will start to take the test, and the test time will be the half an hour, and you can send the question on the chat box so that I can check, or you can send the answer at my WhatsApp number that I have just written, 9871481152, so that we can check how much you have gained the knowledge in 5 days. Okay. Assalamu alaikum wa rahmatullah.